Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, the next one I find interesting, and I'm going to make it a little more confusing than it needs to be, because I find this so interesting for many reasons. Let me start before I go through the facts, because I feel like we're back to 1990, why this happened, and you'll see why I say it. But the statute issue, we're in New Jersey. Now, in New Jersey, there is a statute, New Jersey Statute 59:9-2, which is the Tort Claims Act. A tort is a negligence lawsuit, and it limits personal injury, pain, and suffering claims against public entities. And it says you can't sue a public entity for pain and suffering unless you have a certain type of injury, like it could be a fracture or things like that. But pain and suffering here, what they needed in this case is permanent loss of a body function or permanent disfigurement or permanent dismemberment, where the medical treatment expenses are in excess of very low, $3,600. Yeah. Now, let me start by saying, well, if everyone's saying this is just New Jersey, we're not going to pay attention unless you're in New Jersey. But be warned, because this is interesting. This is why I find this very interesting. In New York and many other states, this language is exactly like our no-fault statutes, meaning if there's a car accident, this is just like the no-fault statute, where you have to prove that you had a serious injury in order to even commence further. Right now, what I find interesting about that is, notice what I just said. You have to prove or establish you have a permanent injury before you can even move further with a motor vehicle issue. You got rear-ended by somebody. Here, so what happened is this. Let me give you the facts. I'll tell you the jury stuff or the judge decision. So here, and this is why I think it sounds like a 1990s pump. Remember in the old pumps, right? And us and probably a lot of other people watching remember this. You would get out, brake, neutral, pump, drive, right? And you'd hit a brake, put it in neutral, pump, drive. Hopefully you didn't forget the neutral part and take it out of drive, right? But when you put it into drive, it was moving the transmission from drive gear to pump gear. And then you'd get out at the panel when we had dials, not the buttony things, and you would rev up the engine. But if you left it in drive and didn't put the transmission, the PTO, right, back to pump gear, your engine takes off on you unless you chocked it, right? Which a lot of times
even if you chock it. Sometimes even if you chock it.
Even if you chock it, go right over it. So I have a client who this happened to, unfortunately, a number of years ago, this exact thing. They turned the dial, revved it up, but forgot to put the PTO back into pump gear, and it took off and hit a house. So here, that's exactly what happened. I don't know why it took off, but it clearly wasn't in pump gear. It was still in drive, and it took off and runs into a business, injuring people, right?
Directly across the street from a firehouse. So they must have been doing this on the ramp. They must have been, at the station, and it goes directly across the street and
right into knock somebody off a desk or whatever. So what happens here is they sue, obviously, but the judge at the trial court kicks it out because they said there's no permanent loss of a bodily function, which is exactly the words in many, like New York's many no-fault statutes. And the appeal court reversed and said it's a jury question whether or not whether the loss of balance that this person suffered was substantial and permanent. What I find interesting, and nobody else is going to, is in no fault world, in car accident cases, this doesn't go to the jury. You can't even proceed to day 2 if you don't establish through affidavits and medical reports that you have a serious injury, one of these things. I'm surprised that the judge says, we're going to let you go all the way through this, right? The appeals court said, we're going to let you go all the way to jury trial, but the jury trial could rule that you have no jurisdiction. That's why I'm surprised, right? That a jury is going to rule on a jurisdiction question. I think the court got it wrong. I think the court is wrong that it's a jury question, and I think it has to be solved by the judge as a trier fact, right, in the first instance, just like no-fault cases. The other interesting thing, which I didn't look up New Jersey's law. Now, she gets hit with a fire truck, right? Injured with a fire truck. There also may be in here no fault requirements, right? So I'm wondering, if you get hit with a truck, it's a car accident, right? Even if nobody was driving it, still arise out of the use or operation of a motor vehicle. Now, I'm quoting New York's language, use or operation, but I'm betting that's most statutes. Are all generally similar, except maybe in Louisiana or Texas or something. But nonetheless, I would have also raised the defense, and if you're listening, I would have raised the defense of the fire department arose out of a vehicle accident, and that trumps this statute, and you have to prove permanent injury, which is not going to be pain or suffering if the expenses are $3,600 or more. I don't know what the New Jersey no-fault statute is, but nonetheless, I would have argued that. But I am shocked that this is going to the jury. I don't know if they'll appeal again. Maybe they didn't even raise it.
They can go up to the New Jersey Supreme Court, so that may be happening. That may be the next step.
This shouldn't be a judge who makes or it shouldn't be a jury who makes a determination about jurisdictional issues, which means, does the court even have jurisdiction to hear about this? And the Tort Claims Act, like, I don't practice a lot in New Jersey, but the Tort Claims Act should have said you don't get to step 2 unless you prove you have the serious injury at step 1. So great. Like I said, I find this very interesting from a procedural standpoint. I don't know whether anyone else will, but
I thought it was interesting from the operational standpoint, but you're absolutely right for the fire lawyers anyway out there. So.
Exactly. And I'm not sure, frankly, on the operational side, other than the old fire engines, I'm not sure if this could even happen again. With the new master controls and everything, could you put it into pump gear and cause it to drive away from the panel? I don't think. I mean, I've never done that, fortunately. But I'm not sure I could do that. I don't know that these master throttle controls allow that anymore. I don't know.